Okay, so that takes care of any issues regarding the jury instructions. I think now would be appropriate to address the issue of the defendant testifying or not and the court doing the necessary colloquy on that. All right, so Ms. Murad, I know we talked about it already in the context of the jury instructions. This is a more formal addressing of that issue. Has your client made a decision in this case as to whether he will testify in his own behalf or not?
He has made a decision, Your Honor.
And what is that decision?
He will not be testifying.
Okay, so let's hand the mic to Mr. Ferriter. Mr. Ferriter, if you could start off by, you can be seated if you like, sir. Go ahead and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can put your hand down, sir. Go ahead and state your name and date of birth, please.
Tim Ferriter, 4/17/75.
All right, and you read, write, and understand English, sir?
I do.
And what's your highest level of education?
College degree.
All right, are you under the influence of any drugs, alcohol, or other medications this morning?
I am not.
Have you ever been treated for any mental or emotional condition?
I have not.
All right, and just to give you the context of why I'm conducting this colloquy, as you've heard, your attorneys advised me that you've made a decision whether to testify or not. And so, as I mentioned yesterday, I need to make sure that that decision is being made by you knowingly and intelligently, freely and voluntarily. So that's where these questions are intended to go to put me in a position where I can make a factual finding on those items. You understand all that, sir?
I do.
All right, and you're represented by your attorneys, Ms. Murad and Mr. Wahid in this matter?
Yes, sir.
And are you satisfied with their services?
I am.
All right, and have they done everything that you've asked them to do regarding the presentation of your trial and consideration of whether for you to testify on your own behalf or not?
They have.
All right, and have you had a full opportunity to discuss with your attorneys the pros and the cons and the risk and the consequences of testifying versus not testifying in this matter?
I have.
All right, and have they fully advised you of all those risks and consequences as far as you're aware of?
They have.
And have they been able to answer all of your questions regarding the various pros and cons, risk and consequences of testifying or not?
They have.
All right. Has anybody, including your attorneys, made any promises, threats, or tried to force you into a decision this morning that would be against your will?
No.
All right, so the reason I ask that is, and you've heard some of this from me before, there are basically three things that a defendant absolutely controls in a criminal proceeding. And what I mean by that is, although you can receive the advice and counsel of your attorneys, ultimately I don't look to your attorneys to tell me what the decision is. I look to you to tell me what your decision is, because your decision is what governs. Those three things are: one, whether to plead guilty or not guilty; two, whether to go to trial or not go to trial; and three, whether once you are in trial, whether to testify in your own behalf or not. Obviously, you've already made and gone past two of those decision points, continuing with your plea of not guilty and also continuing with the decision to have a trial. So now we're at that precipice where I told you we would arrive at one day, once the trial were to begin, as to whether you should make a decision to testify on your own behalf or not. There are certain consequences that I do want you to be aware of if you were to testify on your own behalf. And one of those is that you will be subject to cross-examination by the defense. The only way the defense ever can have an opportunity to cross-examine you in this case is if you take that stand there and you subject yourself to direct examination by your attorneys. Then that opens you up to cross-examination by the state. You understand that?
I do.
Right. Another area is if you have any felony convictions or misdemeanor convictions involving truth or dishonesty, they could also bring that out. Now, does the state have anything like that that it would potentially bring out against Mr. Ferriter if he were to testify? All right, so that's not a real worry. It's a worry for a lot of defendants that come before me, but it's not a worry in your case because you have no history. So the real risk is that you're opening up yourself to cross-examination by the state. Based on the colloquy that I've given you thus far, do you have any questions of the state of the court about anything I've discussed or explained to you this morning? All right, after this colloquy, do you feel like you need to take any additional time to speak with your attorneys regarding the decision that I'm going to ask you to tell me in just a moment?
No, thank you.
All right, have you made a decision in this case whether to testify on your own behalf?
I have.
All right, and what is that decision, Mr. Ferriter?
To not testify.
All right. Based on the court's colloquy of Mr. Ferriter, sir, I find that you're making the decision knowingly and intelligently after having had the opportunity to receive the advice and counsel of your attorney. I also find that I've explained to you the potential risk and consequences of testifying in your own behalf on the stand, including the fact that you would subject yourself to cross-examination. Based on all that, I find that you're also entering into this decision with an appreciation of those risks and consequences, and that you understand the same, and that your decision is being made freely and voluntarily. So I accept your decision not to testify as having been knowingly and intelligently, freely and voluntarily made by you. So that concludes the colloquy on this matter, sir. You may give your attorney back to Mike, and thank you, sir.